Testimony, and this is what I stress. The finding of prejudice that is required by Section 17-16-6 in order for a trial court to prohibit a witness from testifying is not the prejudice that is inherent in the testimony of any opposing party's witness. Instead, the prejudice must arise from the failure to comply with the discovery statute. That's what I'm saying. Your Honor, when you say, they're trying the best they can. There's no evidence they're trying the best they can. They had this evidence in June of 2022, ready to go. Instead, I don't get this evidence until October, some of this. In addition to that, this honorable court, I can't get over the do not serve yet. Do not serve discovery yet, which I alluded to before. It's in here. I attached it to the motion. I can't respond to that. They're responsive. Yeah. So they wrote. I think that's absurd. They wrote. It wasn't done intentionally because we would never have left the logo on. Why didn't we get all of this discovery when required? So those are, I have 308 new witnesses that I'm asking to be excluded. And I'm asking also Mr. Was it 308 new witnesses? Yes, what happened? It doubled. Are those any of those witnesses, for any of those witnesses, any of those you provided in discovery 1 through 12? Yeah. Okay, well, how many new witnesses that you didn't, that are new in 13? I have to get back to this a lot. I have to get back to it. But there's, all that discovery I mentioned, we did a lot more. All that discovery is new. And I'd like to put, you asked us previously, to announce what questions I have for prosecution putting up for. I followed I gave a witness list, as best witness list I could, with current numbers, all date of birth, all addresses. The state had its obligation to do that. And what gives the state the right to decide when we got discovery, when the statute said discovery before trial? And it was ready. Not Gary, 97% ready. So I understand what you took out time. I have a lot more case law, but I gave it to the Supreme Court. And I appreciate that. I was able to look at it. I appreciate you, and I appreciate what you said. That if this was a civil case, it would be easy, and you would exclude it, and I appreciate that. But to me, I've never been in court. But a civil case exclusion seems, I don't know, it doesn't seem as important in a criminal matter. I mean, I have a duty to go and interview you. You would tell me, you would let me interview every witness. I can't do that. So, what can you fashion? You ask, if you're not going to exclude everybody, courts, and I have the cases for you. Courts have said, okay, then remedy it. You're going to know the witnesses. The state is going to, I'm requiring the witness to be interviewed by you. It's not up to them anymore. The state puts you in this position. I have cases of courts I gave to the court and the parties. They will meet with you. I'm going to designate times and dates. The state will not be there. It's not an interview where the state can sit there with you. It's just like if you were out there and interviewing them, and if they won't speak with you, can't get the witness to speak with you, then you come back to me. There's another case, I'll give you the name if you're interested in it, that says that the court sat with the party, the state sit there and say, who are your real witnesses? I'm not show you exactly where they are.
Which case, I want a particular interested, you said proposition to require witnesses to meet.
Yes, sir. I also asked for, obviously, GCICs, which is our meeting call for the,
Unlike those two cases.
yes, sir. Your Honor, it's notice NORRIS versus State, which is 289 Georgia, 154, 2011 case. And on the printout that I give in this honorable court, and the parties. Yeah, on page 3, 2 of 6 going into page 5 of 6. Specifically, Your Honor, the court wrote, this is a court in our state, on page 3 of 6, on the top left. The first line on the right, Honorable Supreme Court, Georgia.
courts also considered 1 through 4 and Court 1, as well as the court's historical reflection, since it was indicted and re-indicted in those sessions of court. I do understand, Mr. Steele, in particular, that this particular discovery is not coming out in the method and manner that it might have been a smoother way to kind of let it go. To proceed, I should say, I define that looking at news and other cases that you would have cited for the court's ratification, that under OCJ 1716, treat a copy of the indictment accusation was a witness furnished. I've also considered 17-16-4, which is disclosure of evidence by prosecution and the defendants. Prosecuting attorney shall no later than 10 days prior to trial, or as the time as the court orders, disclose to the defendant, make available for inspection, copy, and photograph any relevant within the possession, custody, control, of the state or prosecution, any portion of any written record containing the substance of any relevant response to interrogation by any person and known to the defendant to be law enforcement or member of the prosecuting attorney's staff. Then 2 also says state shall no later than 10 days Georgia crime information center criminal history. And 1764 also talks about books, papers, other tangible objects that are in custody or possession of the state or the prosecution are being used by the prosecuting attorney as evidence in the prosecution's case in chief or rebuttal at the time at the Part 2, Article 3, Chapter 12, Title 16, such evidence shall be in 10 days prior to trial. And then it just covers 16 of evidence. And also, I've also considered the information concerning witnesses and about the state's requirement that no later than 10 days before trial, the defendant's attorney within 10 days after compliance with the prosecuting attorney, no later than 5 days prior to trial, shall furnish to the opposing counsel as officer of the court in confidence names and addresses, historical locations, dates of birth, telephone numbers of that party's witnesses, unless the good cause the judge allows exception to this requirement, in which the event counsel shall be afforded an opportunity to interview such witnesses prior to the witnesses being called to testify. And then 1716.6 says that gives the court what to do in terms of failure to comply with discovery requirements. And as with many of the cases the court has considered to include news, which was said earlier. At 316 Georgia 639. At any time brought attention to the court, the state has failed to comply with requirements of this article. The court may order the state to permit discovery or inspection, interview of a person, grant a continuance or upon showing a prejudice and bad faith, prohibit the state from introducing any and such order. In other words, it deems it just under these circumstances. A reciprocal issue if the defendant doesn't disclose or fails to comply with the requirements of this article. The defense has it. So it's the same as being reciprocal discovery of responsibilities of the same. statute 1716(8) says 10 days before trial. I know we commenced trial, and we commenced trial in January, but we have had a long and very arduous jury selection process. And we actually, even though we commenced trial, we joined the issue back in January the 4th of this year, we still have, we're going to, the jury will then be asked to hear this matter. So, ordinarily, without reading what the requirement of 17-16-8, the statutes read together comply with, there is a continuing requirement for those particular statutes to continue to be adhered to. I have some concerns about how the discovery has been meted out in this case. That bothers me because, being an advocate, you do need to get ready for trial. But I don't, and looking at the case law, and looking at 17-16-8, those requirements are set forth to prevent a defendant from being surprised at trial by a witness or to good evidence that is had with defense has not had an opportunity to review or interview. So, I'm supposed to look at exclusion, continuance, prohibition of evidence of both bad faith and prejudice has been found. I don't believe that the state has acted in bad faith and prejudice. I believe that you've all been sloppy. And I think your presentation could have been a whole lot better in terms of the evidence that you have given. It's in a way, in a manner, method. And that troubles me, that concerns me. But one of the things that also concerns me is wanting to make sure that the playing field is level. And I can see how the defendants would be concerned about the representations of your former colleagues about what was done or what was not done in this particular case and what I heard. So to the extent that I'm going to fashion a remedy to permit the defense to have and the state health affairs trial in this particular circumstance, I am going to go ahead at this point in time and require the state by Monday the 20th to submit a pared down list of witnesses for all parties' consideration. The next thing I'm going to have done is choose witnesses you've actually had an opportunity to interview. And if you've not interviewed those witnesses, I'll provide you the opportunity to interview those witnesses. You're probably not going to like when we're probably going to do that because it's probably going to be the time period between we're going to probably be in trial for about 3 weeks. And when we recess, where the state provide those witnesses for you and your colleagues to interview. So I will go ahead. So that's what I need to know. What witnesses you're going to call. So I need to know the universal witnesses. So I'll give you the opportunity to interview them in person or via Zoom or whatever else. We'll work out something. The other thing I'm going to also require them to do for the lay witnesses that they wish to call is that they're going to run all their criminal histories if they haven't been run already. Because that is something that at this point in time, there is no way the defendants can go ahead and avail themselves
themselves the statutory procedure is set forth. So that's the other action that the court's going to make sure that is adhered to. I'm only in order for lay witnesses unless you tell me that there is a professional witness for good cause. For any lay witness is going to testify, it's my expectation to provide that. So, yes, ma'am.
As it relates to the witnesses, as I had spoken with the court before, we did speak with the GBI and the Georgia Crime Information Center, and they told us back when we first brought this issue up that the defendant could have had his GCICs in 2 days. The time that they had then, that the state is literally not just not that we don't have to, we literally are not allowed to. I received that from the counsel. Mr. Steele stated he knew him personally, so I reached out to him personally, to the legal counsel for the Georgia Bureau of Investigation, and one of the requirements of the state maintaining its certification is that we not do exactly that. And what they told me is that all that the defendant has to do is ask the court, and the court issues an order, and they get those witnesses in 2 days from the Georgia.
However it happens, I don't mind how we do it.
Okay.
But I want it to happen. So, Mr. Steele and Ms. Lowe, if you all want to do an order for my signature, I will go ahead and get that done. But I need to know the universal lay witnesses that you all want, because there may be some you just don't want to have with it. GCIC's run for. I mean, I'm not saying you should. I'll order all of them, but if you don't, if there are witnesses that really don't need that, there's no reason to run their criminal history. I would just say you exercise on the side of caution, but I will prepare an order such that they can get the criminal histories run.
And Your Honor, they said at the time I told them the number of witnesses, and they still told me that number of days. They said at the time 2 days.
That may work. That may work. If we do it now, that shouldn't be an issue. But I want to take that up on Monday, because I want to make sure that we're dealing with that particular universe of witnesses.
And I'm finding that, so that I can forward it to the court and to counsel for each of the defendants regarding how to do it.
I want you all to think about it, and you'll be prepared on Monday to go ahead and write and prepare this, have the court sign that order. But I at least would like to know Monday how many witnesses you are planning on calling. I think that would be helpful, because if it's not just me, you can, it's like much in civil cases. You may have, hundreds of witnesses that might be subject to call, but there's the main call list, there's the will call list, and then there's everybody else, the kitchen sink list. All right, so, if you definitely know you're going to call these people, then, we're going to call these people. You're going to call them, subject to other things. I understand that you may have to call the people depending upon the circumstances of it all, but I just can't believe that you're going to be calling 737 witnesses.
Okay, we can work with that. Thank you.
At this point in time, it's just the reason I'm doing that, Ms. Lowe, is primarily because I share Mr. Steele's concern of constitutional issues in terms of being able to represent his client and the other similarly accused person. So while I don't mind because you committed bad faith intent, I think that the disclosure and the way that the witness list is kind of developed, definitely I have concerns about it. And the way that I resolve those concerns is to make sure that they're not surprised by anybody that you're going to call, and that they get everything that they should have gotten. Mr. Steele? Okay. All right. Sir, if you prepare a suitable order for my signature. With those
two things, or three things I should say. But folks, to the extent that, we want to get this done, I really don't want to have any other surprises with stuff that kind of comes out in terms of things that have not been disclosed. I really do, but we are very close to going trial in terms of summoning our jury, starting on 27. So we really need to go ahead and bring everything kind of to a close, and there should be no surprises at this point in time.
Yes, Your Honor.
Mr. Steele, you prepared an order, like I said, about the 20th. Everybody else, so for my consideration, send that to this lovely Senator Collins. We'll go ahead and do that. Okay. All right, you're welcome. All right. Mr. Helsky, what's your pleasure in regards to the constitutionality of the statute? I hope that you got an opportunity to take a look at Massey. That's why the court was kind of concerned about that, understood, in terms of just being able to perfect the record, because it seems like no matter what kind of analysis, constitutional or otherwise, that the court makes, they still need to have that was not done at that point. So this court doesn't kind of want to make that same mistake and wants to go ahead and at least, that's why Mr. Harvey was very, I think, thoughtful in putting that together in terms of just the evidence that the court will be able to sift through for themselves and determine whether or not that framework is something that they can consider as being absolutely a question of whether or not it's a citizen, the persons are citizens for purposes of their application to by statutes. And to that point, Your Honor, the state agrees, and I appreciate Mr. Harvey's submission. We, as stated yesterday, we believe that we don't get to the point where the state has a burden, but in the interest of caution, I have prepared some exhibits that I've allowed my counsel to review, and I have an index that the court can view as I'm going to run through them and ask. Okay, I'll take the index, please, sir. Yes, sir. If I may approach. You may approach. These are all authorities that were cited in the September 19th brief, so there's no surprises here. These are just actual exhibits of those authorities. So, and with the Honorable Court's permission, I'm just going to go through and list them and say where they are in the brief, and then I'll ask to admit them all in total, individually, just to save time. So just to get going there, Exhibit A is going to be Surefoot LC v. Surefoot Corp. 531 Federal 3rd, 1236. The pin site in the brief is 1243. It's a 10th Circuit case, 2008. That's the state's response at page 3, footnote 1. B is it's a law review article by Carlton F.W. Morrison. For exceptions in search of the District of Columbia versus Heller and Judicial FC Dixit. That's 62. That's also at footnote 1, page 8. Firearms in American History at Rome by Charles Winthrop Sawyer. That's a 1910 publication. That's at State's Brief at 4. Exhibit D is going to be Poe v. Ullman. That's 367 United States 497. Inside in the brief 542. That's also on page 4. E is going to be Ancient Laws and Institutes of England at page 3. Benjamin Thorpe as 1840 edition. That's going to be also at page 4. F. This is going to be from the Journals of the Continental Congress, 1776, and that's at issue 5. It's a 1906 publication. It was originally printed in the Pennsylvania on March 20, 1776. That's State's Brief, page 7 and 8. G is going to be a Maryland Act, Acts of Maryland 14, as year 1776.
as 1776 Mass Laws 479, Chapter 21. It's at page 8. 8 is going to be Statutes at Large of Pennsylvania from 1682 to 1801 at pages 559 and 560. It's a 1902 publication, also at page 8, State's Brief. I is going to be the State Records of North Carolina at 89. That's a 1905 publication. That's also at page 8. J is going to be a May 5, 1777 Act, and it's included in headings Statute and Statute at Large at page 281 and 82. Cited in the brief as 9 William Walter heading the statutes at large being a collection of all the laws of Virginia at 22. It's an 1820 is going to be 1779 Pennsylvania Laws 193. An act for disarming persons who shall not have given attestations of allegiance and fidelity to the state, as section 5 is cited in the brief at page 8. 7 is a scholarly article, historical scholarship. The right to arms does the Constitution with the predilection of judges reign. 36 Oklahoma Law Review 65 at 96. Robert Dolet wrote that. That's a State's Brief, page 9. And it's going to be another historical authority by Don B. Cates. Handgun prohibition and the original meaning of the Second Amendment. That's at 82 Michigan Law Review 203 at page 266. It's a 1983 article. That's a State's Brief, page 9. And it's going to be also by Don Cates, a modern historiography of the Second Amendment. That's at 56 UCLA Law Review at 12/11/12/31 Penn site. That's note 100. It's a 2009 article. State's Brief at 9. O. Stephen P. Halbrook. To keep and bear their private arms. The adoption of the Second Amendment. That is from 1787 to 1791. And it's at 33. It's cited in the brief variously as 3 different items. One was Bernard Short's Bill of Rights, a documentary history. Another one was that it was a Boston Independent Chronicle newspaper article. And then also we cited Stephen Halbrook, That Every Man Be Armed. 86, the revised edition 2013. But again, that's at page 9 and 10 of the State's Brief, and that's Exhibit O. Exhibit P is going to be the debates in the several state conventions on the adoption of the federal constitution. 36, that's a second edition, 1836 publication by Jonathan Elliott. That's at State's Brief, page 10. Q is the address and reasons of the Assembly of the Convention of Pennsylvania to their constituents. At page 8 of 29. We cite this in the brief at pages 10 and 11. R is the case of Interrupt the Attorney General of the United States of America, 836, Federal 3rd, 336, 368 Penn site. That's a 3rd Circuit 2016 case, and that's at State's Brief 11. S is an 1804 Missouri Law, 90. That's at page 11. T is also an 1804, but Indiana Act at 108, also page 11. U is 1806 Maryland Laws 44, that's also page 11. V is 1851 Kentucky Acts 296, also page 11. W is 1860 to 1861 North Carolina Sessions Laws at 68, also page 11. And I think X is 1863 Delaware Laws 332, also at page 11. Those I include just so that I'm not accused of cherry picking history. Those are just some laws that were in existence at that time, Your Honor. They're not particularly helpful in my argument, but they're included nonetheless as exhibits. Y, 1878 New Hampshire Laws 170, Chapter 38 and Section 2. We cite this in our brief at page 11. Z, and it goes to WW, just so there's an end in sight here. Yes, sir. Z is a digest of the statute law of the state of Pennsylvania from the year 1700 to 1894. That's at 541. That's an 1894 publication, 12th edition. We cite that in State's Brief at 11 and 12. AA, annotated statutes of Wisconsin containing the general law on 1st October 1, 1889 at 940. 1889 publication. We cited at page 12. That would be State v. Hogan. 63 Ohio State 202 Penn site 218, 219, that's a 1900 case. That's page 12. Go to C. General statutes of the state of Kansas at 353 and 1897. Digest. That's at page 12. Double D. 1880.
I'm going to stop right here, y'all. I believe that this is going to be the longest trial. Y'all remember the Watergate? Yeah. Y'all tell me what y'all think about this trial. How you think it's going to be?